Hey everyone, welcome back to today's video. This one's a short but intense one because we're looking at a courtroom moment where someone just can't seem to stay out of their own way. Before we dive into it, I want to give you a quick preview of what's coming up this week on the channel, including the return of Judge Tammy, who you guys absolutely loved in the last video, as she completely and confidently shuts down another sovereign-style argument in a way that's both satisfying and impossible to ignore.
If I enter like an oral motion of dismissal based on constitutional grounds, are you standing on your constitutional oath?
I'm not sure what that is.
In regards to the right to travel under the 14th Amendment.
Okay, so that's not actually in the Constitution.
I just wanted to point out to the court that automobiles hadn't been invented when the 14th Amendment was ratified.
When the amendment was officially ratified, it firmly strengthened the legal foundation behind these decisions, which brings us to Judge Perkins clearly and confidently breaking down why the court absolutely does have proper jurisdiction. He carefully explains the legal authority in a way that leaves no room for confusion, shutting down the weak arguments being thrown around in the courtroom. You can see the patience in his approach, but also the firmness in his tone as he makes it clear that the court's power in this matter is not up for debate. Every point he makes reinforces that the process being followed is grounded in law, not opinion. It's one of those moments where the facts take center stage and the reality of the situation becomes impossible to ignore.
Mr. Gray, are you trying to get a driver's license?
Your Honor, I'm here by special appearance.
I knew that was coming. I knew that was coming. Let's just talk a little real simple, basic stuff. Are you trying to say that you can just run red lights, you can just speed, you can just do what you want to do on the roads without any repercussions at all?
Your Honor, is this a court of record? I'm sorry, is this a court of record?
As far as I checked, it was, Mr. Glenn.
Yes, it is.
To close out the week, we're dealing with a completely out-of-control courtroom moment, where a highly agitated defendant goes off the rails and starts making dramatic threats about suing the court if they dare to continue the case. She doubles down on the confrontation, refusing to accept how the system works and trying to turn the spotlight on herself, as if intimidation will change the outcome. The tension in the room builds as her behavior becomes more chaotic, but the court remains calm, professional, and firmly in control. It's the kind of moment where reality crashes into fantasy, and the contrast between emotion and authority becomes impossible to miss. By the end, it's clear that no amount of threats or theatrics will stop the process from moving forward.
Romulus, I guess it would be Van Buren. And if the court proceeds with this, I will be also bringing the malicious prosecution against this court as well, because these are erroneous charges and they're retaliatory, which is a violation of my freedom of speech. It's a violation of my right to due process. So if this does not get dropped today and it moves forward, I will be filing under color of law lawsuits against Van Buren and this court for violation of rights under federal question jurisdiction. So I just don't think it would be a good use of the court's time or resources to continue this malicious prosecution. They completely ignored my evidence. There was sexual discrimination against me because I was a woman. It would really be a waste of the court's time.
Yeah, we've got a wild week lined up, so let's dive right in and get things started with full momentum. This is going to be one you won't want to miss.
Okay, we're on the record in McNamara versus Sylvester, case number 2018299. The record should reflect Mr. Sylvester has appeared today by Zoom video. We also have Mr. Brzezinski present on behalf of friend of the court. This is set for a show cause hearing today regarding support. And Mr. Brzezinski, can you give me an update on this case?
Yes, Your Honor. This hearing was adjourned from February 6th for the defendant to pay $200 plus stay in communication with the friend of the court if he did not have that ability to pay. He has a support obligation of $363. This is now, I believe, the sixth show cause hearing since June 22nd of 2022. The last payment was August of 2022 at $400, so most of these hearings have not resulted in payment. Multiple times the defendant has been ordered to provide job searches to the friend of the court, which he's done, but it has not resulted in him gaining employment or making any payments. So the friend of the court would ask if he does not have employment or any income, that he provide proof of that, whether it be unpaid bills, rent, proof that he's going to the interviews, just verification of all those details to prove that he truly does not have an ability to pay.
Well, I can tell you that my phones are currently shut off with a past due balance of almost $900, if that counts for anything. And I'm behind on my mortgage. That's $606 a month. Currently don't get an electric and gas bill because something's wrong with consumers. But I can tell you that we're behind in that too. There's only one income in this house, and there is a baby due next month as well. There should be a payment made. I just filed my taxes. I received my state taxes. I know you guys do with income withholding on that. So you guys should be getting a payment from my taxes. I was supposed to get 600 and some change, and I only received $238 back. So there should be a decent payment going to you guys out of my taxes.
Mr. Brzezinski, if the court proceeds with contempt proceedings at some point, would this be a first or subsequent finding?
I believe this would be a first finding of contempt, Your Honor.
Okay. All right, so I'm going to set this for a contempt hearing in April. Mr. Sylvester, there's a couple of things that you need to do under the law. And number one is to make your payments, of course.
Okay, well, I have absolutely zero
income. Can you listen to me for a second?
No, I'm listening. You guys tell me this every...
I always say it's never a smart move to show up to court acting reckless or unfocused, but some people just don't get the message. So let's break down what's really happening here and how he's actively hurting his own case. If he had actually listened to the friend of the court, he would have heard them clearly say that while he was behind on child support, there was real evidence showing he was genuinely trying to find work. That effort actually matters in court, and it goes a long way, even if he hasn't landed a job yet. But with one out-of-line comment, he basically erased all the goodwill that had been built up for him. And unfortunately, he didn't stop there, making his situation even worse by the second.
Language, you're in a court.
Okay, what are you going to do?
What am I going to do?
I don't come up there.
I'm going to hold you in contempt. I'm going to issue a bench warrant for you to be arrested. Do you want that to happen?
No, but you guys tell me this every time. I have 92 applications out on fucking Indeed right now. I can't help that I can't stop.
I get it. You're frustrated, but that's the second time you've completely derailed yourself. Now the judge is about to give you one final warning, and I strongly suggest you get focused, keep your composure, and stop making things harder on yourself before this situation gets a lot worse.
Based on your language, I've already warned you one time. If you use that language again, I will hold you in contempt.
Okay, well, as I was saying, I cannot help that I can't get a job. Okay, so I've had some places call me back, but it doesn't get me anywhere. I've had 2 interviews out of all of my applications. We've got one vehicle, one income. My insurance is actually almost expired because I can't pay that either. I don't know how I'm supposed to make payments when I don't have an income. I don't know how you want me to prove it, but I'll prove it.
Are you done?
Okay, I see where this is going.
Are you gonna listen, or are you?
Oh, I'm listening. I'm gonna get my shit trained.
Before you end up in jail for contempt, because the judge has already given you more than enough warnings to control yourself, and you still kept pushing your luck thinking a virtual courtroom made you untouchable. Here's the reality. Yes, you're behind on child support, and that part is a fact the court can't ignore, so they're required to schedule a contempt hearing. But that doesn't automatically mean you're guilty. It simply gives you a chance to present the same evidence you try to share today, just in a calm, organized, and respectful way that actually helps your case instead of hurting it.
Right. You just use more inappropriate language. So I'm going to, based on your conduct here at this hearing today, I'm going to find you in contempt. I'm going to order that you serve 30 days in the Otsego County Jail for contempt in the view of the court. This is a summary proceeding, and that's based on your conduct here in front of the court.
I'll speak it to a lawyer.
I'm going to issue a bench warrant for your arrest. You'll serve your 30 days here once you're arrested and brought before the court. I'm also going to set this for a contempt hearing in April. If you aren't employed and you can't make payments, you need to provide proof of that to the friend of
Okay,
the
how?
court.
You guys don't tell me any way how.
Or bring proof of that to the hearing in April.
Okay, you guys want proof, but you guys, right here, this is exactly what I'm.
Okay, I'm muting Mr. Sylvester now because I need to be able to make a record and he's talking over me.
Because you guys don't give me a chance.
I gave Mr.
Hey, Ben.
I know you count on me, but I keep messing up and can't seem to stay out of trouble. And honestly, that's the hard truth. I'm all for watching someone dig their own hole with reckless choices, but it crosses a line when innocent people end up paying the price for that behavior. What really makes it worse is that disappearing on the judge or avoiding the situation won't help him or his family at all, and it only guarantees that things are going to spiral faster and hit much harder later.
I've given you more than an adequate opportunity to talk here today, and at some point you have to listen and you're not doing that, so I'm muting you because I need to make a record. So if you don't provide that proof to the friend of the court at the hearing in April, or bring it or provide it to the court for the hearing in April, then the court will issue or proceed with contempt proceedings, and you could be subject to a contempt penalty of up to 45 additional days. So Mr. Brzezinski, if you can set that for a hearing for contempt in April, I'm going to issue a bench warrant for the court's finding of direct contempt here on the record today, which is a separate issue that you don't need to deal with, Mr. Brzezinski.
Okay, thank you, Your Honor.
All right, everyone. That wraps up today's video. Short, sweet, and a perfect setup to get you ready for the wild week ahead. I promise you won't want to miss what's coming next. If you enjoyed this one, hit that like button. If not, leave a dislike, but make sure to drop a comment with your thoughts. And don't forget to subscribe with notifications turned on so you never miss any of my content. There's plenty more chaos, courtroom drama, and jaw-dropping moments on the way.